Welcome to an oral argument session of the 5th District Court of Appeal. Can everyone hear me? You can just give me a nod. Can everyone hear me? Okay, we have a lot of attorneys on today, more than usual. That's fine. But if each side could sort of let us know who is making the argument so that we're not searching around on our screens for who's talking, that would be helpful. At this time, if you could just think about whatever electronic devices you might have going and silence those or turn them off. That would be helpful so that we don't have distractions. And here on the docket today, we have one case, 23-2347, Lesbar Enterprises versus Carrie Baker as property appraiser for Lake County, Florida. With that, my name is Judge Eisnagel. I'm joined on the panel today by Judge Harris and Judge South. And with that, if the appellant could go ahead and identify themselves, let us know who will be making the argument, and then I'll recognize you to proceed.
All right, Your Honor. Thank you. Philip Smith with Macklin Burnside for the appellant. I'm ready to proceed if it pleases the court.
Counsel, you're recognized.
Thank you. We're here today, Your Honors, to seek the reversal of an order dismissing with prejudice the complaint that we filed in this action, seeking a review of the agricultural tax classification denial by the property appraiser and the value adjustment board. This particular hearing today is a de novo review because it was a dismissal with prejudice of the lawsuit that we had filed under the applicable statute 194.171. It is important to note that at least in the trial court, there were allegations that this was a DEC action, that the court didn't have subject matter jurisdiction, and a few things.
Counsel, you appear to argue in your brief that one of the grounds for reversal appears to be that you were not given an opportunity to amend your complaint. Did I read is that one of the grounds for reversal that you raised?
It is, Your Honor. We believe that the complaint actually does state a cause of action, but if there is something that needs to be pled that wasn't pled, we should have been given an opportunity to amend, because I think, as the court will find in these cases that we're about to go through, that the issue of intent and classification of property, as noted by the Conrad court, is an issue of fact. And as we know,
Counsel, if we could just take the opportunity to amend issue first. Perhaps that's the simplest issue, perhaps not. But I have two questions about that. First, preliminary type question. Was there a responsive pleading filed in the case?
There was not, Your Honor. Just a motion to dismiss.
Okay. And for these purposes, did you ever request an amendment? And if so, where in the record can I find that?
Yes, in the hearing on the motion to dismiss, during the oral argument, and it's contained within the transcript, we said to the court, if you find that the pleading is insufficient at a minimum, we should be offered the opportunity for leave to amend. So we did. Yes, Your Honor.
Okay.
So going back through the complaint, and we believe it is currently, in its current status, sufficient. We have alleged that this is an original jurisdiction case under 194.171. The taxes were paid in protest, but that is required of the statute. The circuit court proceeding should have been de novo and should not have relied on facts contained anywhere, including with the VAB's attachment that was part of the complaint. And this is a agricultural classification case. It's not a valuation case. They are slightly different. In this case, in the trial court, there's no presumption of correctness to either party. but the party bringing the lawsuit has the burden of proof, much like any other case. So that's the standard for which we should look at this case, is did we plead a cause of action? If you look at count one, we alleged in the allegations, specifically paragraph 15, which is record R6, the K9 facility consists of an indoor climate-controlled dog training and exhibition facility. There's going to be outdoor trailers. There's RV connections and hookups for the participants for the agility training, all of the events that would take place in relation to the K9 facility that's being built. Additionally, the K9 facility is going to be used for dog training, for private and public events, clients, including but not limited to K9 police and military training, K9 agility exhibitions and competitions, and as an inclement weather protection and shelter for the domestic and exotic livestock and other animals that are located on the property. These are
Mr.
some of
Smith,
the
you say a lot of what the facility's gonna be used for, gonna be at some future date. Why do we care?
Well,
What
I
was the
think it's
property used for on January 1st?
well, I think that's a good question, Your Honor. And if you'll look at the allegations as we continue on, specifically paragraphs 18 through 21 of the complaint, R7 and R8, we allege that the owners own, train, and enter competitions and have done so and won already 650 qualifications award and did so in January 1 of 2022. So understand that this was already a place where the owners who were licensed and permitted were already performing this function of owning and training canines, and simply went on to expand its agricultural business by adding the agricultural canine facility.
So hold on. So where is the allegation that the canine facility this part of the property we're talking about is 2.61 acres, correct?
That is correct, Your Honor.
Okay. So that specific 2.61 acres, that's the only thing at issue here in this case. Where is the allegation that 2.61 acres that the parties have labeled the canine facility was currently actually being used for the training and the exhibitions and things?
Well, respectfully, Your Honor, we're complaining about the entire acreage within the property. And if you look at the value adjustment board attachment, for example, the value adjustment board even found that it was currently being used for agility training. Exhibit D to this complaint, the special magistrate acknowledged that 1.41 acres of the property is currently being used to house large cats and our exotic animals. It was in use as of the time. The 0.65 acres to the south of the home site on the property currently has a dog agility course as well as cages for exotic animals on it. And this other property was also being used until they decided to push the property over and start building the facility. So it just seems a bit unfair if it's already got agility courses, it's already got exotic animals with cages, as recognized by the special magistrate, that the act of trying to improve your ag business by building a facility would somehow classify it as not being ag at that point. Now,
where's the allegation in the complaint?
well, the allegation in the complaint is, let's go to specifically.
And then I'll ask you to tell us where you are specifically argued that in the initial brief. But tell us where it is in the complaint first.
Well, in the actual complaint, Your Honor, if you go specifically to paragraphs, let me get it here, 18 to 21 where we've alleged it.
Well, you allege in 18, for instance, the canine facility, which as I understand it is the 2.61 acres.
That's right. And
Okay.
then
So you say,
goes
hold on. You allege the canine facility will be used for the agricultural purposes of housing, training, holding expeditions, housing, shelter as needed for domestic and exotic livestock, and storage for agricultural tools and equipment. That seems to indicate, I mean, as I read that, it seems to point to the 2.61 acres that was under construction.
That is correct. That's a portion of the property in dispute.
Where does the complaint allege that the canine facility, which again, as best I can tell, that's the part of the property we're talking about in this appeal. Where does it allege that the canine facility, that 2.61 acres, was in any way being used for anything other than an active construction site on January 1st, 2022?
Well, the paragraph 21 states that the operators of the canine facility and the principals of LESBAR own, train, and enter competitions and trials of agility dogs with dogs owned and trained by the Kalmansons.
But that's what they've done. That all that says is that's what they've done. That says nothing about them doing that on the 2.61 acres.
Well, understand that this property is all contiguous together, and it's recognized again by the Value Adjustment Board. They concede as a fact that there are dog agility tracks and so forth. And so they just took a portion of this property to start building this facility. And it's 40%.
I understand. And that's the part of the property that did not receive the ag designation, correct?
The canine facility, nor the other two parcels that I'm discussing, which we appealed for, we're complaining about.
So I don't think paragraph 21 gets you there. I don't think paragraph 21 specifically says on the part of the property at issue in this case, on January 1st, 2022, we were conducting, competitions, dog training, etc. Is there any other part of the complaint that might allege that?
Nothing in the complaint will allege that, but this.
Well, Mr. Smith, what did you mean by paragraph 28? Let's look at that.
So, 28 just is an allegation that we say as of January 21, the denied property was being used primarily for bona fide agricultural purposes. So it's
your argument then that the dog canine training facility is a bona fide agricultural purpose?
Absolutely, Your Honor.
But you don't allege that.
That the canines are agricultural purpose? Absolutely, we do.
You don't, but here's the problem. You don't actually allege that the canine facility was actually being used for any of that on January 1st, 2022. I mean, if you do allege it, please point it out, because I'm just not able to find it.
Well, and respectfully, Your Honor, I understand, and we concede the building itself for the improvement of this agricultural business was about 40% complete. But if you look at—
Well, that's as of when? 40% complete as of January 1, 2022?
2022. That is correct, Your Honor. And the cases are replete with, if the parties can show, and even the Bystrom case, which is very informative as to this.
Counsel, I read Bystrom. I actually think it cuts against your position.
Well, I believe that if you go to the sort of the middle of right at the bottom of 587 of the Bystrom case, the court recognizes that the act of, for example, in a case involving products, if the act of clearing, if combined with other actions evidencing the property owner's bona fide intent to use the land for ag purposes, it's sufficient to show that the clearing of the land constitutes an agricultural.
Was the clearing of the land, and was this in the context of planting crops?
It was, but
yes.
The point
so
is,
if you clear counsel, if you clear the land, the land is ready to be cultivated and planted, then, correct?
but it wasn't cultivated and planted, but they
Right.
said that would be enough.
But it was ready to be. With
Well,
with a facility that you agree that is undisputed that it was in the midst of construction. It wasn't, you haven't alleged that it was even any agricultural sort of activity could have taken place on January 1st, 2022.
fair enough. If that's the case and the court felt that way, then we should be allowed an opportunity to amend the complaint, because here again, this was dismissed with prejudice with no opportunity to amend.
Why would
Clearly not the
amendment,
standard.
why would amendment not be futile?
Well, amendment, if we were to dive into the facts of the case, perhaps a portion of that building was in fact used to hold animals. I know that it's a big facility. The property surrounding it is all used for exotic cats. The entire property is ag, and it has been. And one distinction that I'd ask the courts to look at, every case that you're going to hear about from the appellees, in every case where they didn't take a look at the intent and the actions of the parties because of the actual use on January 1, in every case, the property was being used on January 1st for a non-ag purpose. Here, there's no statement that our property was being used for non-ag purpose. So that's a distinction in these cases. And that's why Bystrom is supportive of our case, because Bystrom wasn't a case in which the property was being used for non-ag purpose. If you take the case that the appellees cite and rely on, that was a case where in one situation, it was an existing bank. And in the healthcare case, if you look at the prior use on January 1, it was rented out as a motel. So the actual use on January 1 in all of their cases, it was actually used as a non-ag use. That is not true in this case.
Counsel, you're into your rebuttal time. It looks like you have about 4 minutes left. Do you want to keep going, or?
Well, I'm going to use one more minute to sort of summarize. If you take a look at the cases, we know, for example, that the canines are useful to humans. We know that. I don't think anybody in this panel would disagree with that. We also know that if you follow the statutes, that would constitute an agricultural use. We know that except
Counsel, I'll stop you there. I'm not at all sure that's correct, but I guess the question is do we get that far? But I'm not prepared to say that an agility operation, dog training and agility operation is necessarily agriculture, having read the statute. But so I don't know that you should take that for granted. Well,
all right, fair enough, Your Honor. I will say that in 2011, the statute 193-461 was amended to add Florida statutes 823, and Florida statute 823 says that a farm product can be an animal useful to humans. That was an amendment for 2011, and the prior cases don't apply. I'll save my rebuttal time. Thank you.
Thank you, counsel. All right. And with that, we will turn to counsel for the appellee. If you could please identify who's going to make the argument, and then I'll recognize you.
Good afternoon, Your Honor. My name is Summer DeGell from Gray Robinson, and I will be making the argument.
All right, counsel, you're recognized.
Thank you, Your Honor. As I said, I'm Summer DeGell with Gray Robinson. My law partner, Tom Wilkes, is also on the screen, and I will be arguing on behalf of appellee Carrie Baker as the Lake County property appraiser, as well as the fellow appellees, the Department of Revenue and the tax collector for Lake County. To resolve this case, Your Honor, the court merely needs to look to the statutory framework for agricultural purposes and classification.
Did the appellant ask to amend their complaint below?
They hinted that it would be a great way, or they should be allowed the chance. I'm not sure it was a formal request. There was never a motion filed.
All right, we can check the hearing transcript again to sort of decide that, but let's assume for a moment that they made a sufficient request to amend. And as best I can tell, they hadn't amended yet, correct?
Correct. Yes.
And there hadn't been a responsive pleading filed, correct?
Correct, Your Honor.
don't we have binding decisions here in the fifth that say that under those circumstances, that even if the amendment is futile, that when there hasn't been a responsive pleading, and that when there hasn't been a prior amendment, that the trial court has no discretion to deny the opportunity to amend once?
I'm not aware of those cases, Your Honor, but I will not dispute or argue with you on those. I believe that the law is when amendment is futile, that you do not have to give the chance to amend. And here we have a case just like that, where it is absolutely futile. There are no allegations that can be made to show that this canine facility, and I do want to go back to that, the only property being challenged in the complaint below was the property defined as the canine facility. It was the 2.61 acres. It was not the other areas that were denied the agricultural exemption. So we are focused solely on that 2.67.
I mean, why can't they amend? Why couldn't they? Now, look, the truth of what was actually happening, right? Obviously, every attorney has an obligation of candor to the court, obviously, right? But assuming that the facts actually were such, why couldn't they amend it to say, look, we were storing farm equipment on the property on January 1st, 2022, and we had 20, tractors and all this other farm equipment. Why, if they were doing that, then why would their amendment be futile then?
The VAB decision that they attached to their complaint, which will be incorporated into all of this, goes through what was occurring on the property. There is no mention, there was no evidence submitted at that point to show that any of that would be a truthful statement, Your Honor.
Well, but I mean, does that foreclose their ability to make the allegation in the circuit court?
They are, have to abide by their duty of candor. So potentially, yes.
Well, I mean, let's say for a moment that there were 20 tractors and other farm equipment being stored on this 2.61 acres, and they just, through negligence, neglected to mention it, right, in the administrative hearing side of things. Are they foreclosed from raising it in the circuit court at that point?
If that was a true statement, then they would likely be entitled to a chance to amend.
Okay.
Mr. Gale, let me ask you something along those same lines. In the property appraiser's motion to dismiss, chapter 194 is referred to specifically. It's argued that improvements have no value until they are substantially completed, for whatever that's worth in this case. But you point out that the plaintiff never alleged substantial completion, either on January 1st, 2022 or any other time. Why does that matter?
Because the property appraiser, pursuant to Florida statute 192.042, the date that they're required to determine the taxable status, January 1st, that statute goes on to explain that if a building is not substantially completed as to that date, it is given no value. So
Okay.
at this point, you have
That kind of leads to my next question then. If it's a material pleading deficiency that could be remedied by the filing of an amended complaint, was it error to dismiss without giving the plaintiff an opportunity to so amend?
In this case, we've already had the admission from opposing counsel that it was not substantially completed. It was at 40%. And paragraph 16 of the complaint, which was filed more than a year after January 1st of 2022, still alleged that there was still a minimum of 4 months until completion. So no, they could not amend to allege substantial completion.
Well, I guess in a related argument, it's argued again at the motion to dismiss hearing. This is in response to, I think, the judge's hypothetical on a dairy farm, that this case is different because there's not any equipment in the building. A couple of questions about that. First of all, where can I find anything within the four corners of the complaint about, or the attachment, that there's nothing located in the structure of the building, no equipment? Where is that in there? How is that appropriate or proper to argue?
Because the complaint and both the VAB attachment, which is Exhibit D to the complaint, show it's an active construction site. The building is under active construction. That's not being used as a building. It's being used as a construction site at this point.
So if they would have or could have alleged or still could have alleged that a portion of the building is complete, while the building itself may not be complete or substantially complete, a portion is complete, and that portion presently stores equipment that's going to be used in the canine training operation. Would that have mattered if they would have alleged that?
Potentially. So when you look back at the cases, I believe it is.
Again, okay, so if that would have mattered, why shouldn't they get a chance to so amend, to correct that
What
pleading deficiency?
it does, and the reason that that's not the case going on here, Your Honor, is the property appraiser has the ability to look at that building and divide it up into the parts if that's what was going on here on the ground. It was the case of the Miami-Dade Community College case from the 3rd District, where you had a building, it had been split. Part of it was being renovated to be used as the community college. They were only challenging the portion for that property of the building. And because there was not an active college going on, the actual use as of the date, the court found against the property owner. In this instance, the property
Is that
appraiser.
case resolved on a motion to dismiss?
I do not believe so, Your Honor.
Okay.
The reason the motion to dismiss at this stage is those cases have set the precedent in the case law, what actually comes into a cognizable action at law since that time. And here, based on the 4 corners of the complaint and the attachments to it, we are able to see that this building and this 2.61, at one point in the record, it said 2.67 acres, is used solely for a construction site. For those reasons, and those very unique reasons, is the reason that amendment would be futile in this matter. The actual use doctrine, as we have said, is well established, and it is dispositive of this appeal. The courts, including the Florida Supreme Court, have consistently ruled that Section 193.461 is predicated on land use. That is the physical activity on the land as of January 1st of the tax year, in this case, 2022. As I've stated in our reply brief and today, Lesvar's complaint and the attachments make it clear that the use of this property, the sole 2.61 acres, was a construction site. A construction site is not the preparation of property for an agricultural purpose like forestry cases or crop cases. It is an active construction zone. Preparing the land, as the statutes explain, is not pouring concrete and putting an AC unit in. When we turn to the Cedars of Lebanon case, again, the certified question there is where the care center is designed and restricted to hospital usage. Is it entitled to an exemption from the ad valorem taxation prior to actual use as such? The answer is no from the Florida Supreme Court. The Cedars of Lebanon and the community college case are important here because they're dealing with a building. The exemption that they were applying for had to do with the use within the building, not necessarily the use of the underlying land. When we're classifying properties as the property as appraiser is required to do as either agricultural or non-agricultural, you're primarily looking at the land and the use of the land. Here, there was no active building. There was no operation. That's clear from the complaint. That's clear from the exhibits to the complaint. You can look at Exhibit B to the complaint. You see the aerial that has been outlined. You can see the outline of the building underneath the hashed marks. This building took over the majority of your 2.61 acres. So you, as the court and the trial court below, were constrained to find what happened on the actual use as of January 1, 2022. And all it was a construction site. That's not the same thing as preparing property for crops. That's not the same thing as keeping land for forests.
Counsel, if we just made one little change to the complaint and the complaint said the canine facility was 100% complete on January 1st, 2022, and that it is imminently going to be used for, and then they listed all of the things they currently list in the complaint, you know, everything from dog training and agility to storing livestock at quote as needed to storing agricultural equipment, and I'm probably missing a few things. At that point, would you agree that they have that now they get past the motion to dismiss at that point?
No, Your Honor, I would not.
Why
Again,
is storing agricultural equipment in the canine facility, why is that not sufficient to get them past?
Your Honor, your question, did it not presume they didn't store it until after January 1st?
No, let's say that they alleged it's imminent. Like we're bringing all the farm equipment there right now. We were bringing it on January 1st. It just wasn't there yet, but it was on the way, you know.
The Cedars of Lebanon case, Your Honor, points out that it is aware of the hardships that the actual use doctrine can have for taxpayers and property owners.
All right, let's change it. Let's say that they alleged that they moved the farm equipment in at 11:59. January 1st, 2022. Did they have enough in their complaint to get them past the motion to dismiss?
At that point, they would have to turn towards whether or not it was a bona fide agricultural purpose, and it was primarily being used for that, Your Honor.
Okay. Okay.
To finish my thought on the Cedars of Lebanon case, it does indicate that the actual date, again, is January 1st, the assessment date, even if that exempt use begins in February, not quite as the same as your example, but close for the case law, that the exemption should not be granted because it was not in use as of January 1st of the tax year. So it's the hard truth of the law in that instance, but it is the date that matters. The intention, as many of these cases state, is not what matters here. It is what occurred on that date, physically presently occurring on the date of assessment. Are there any other questions?
I'm seeing none. Thank you, counsel.
Thank you.
And with that, we will turn back to counsel for the appellant. It looks like you have about 2 minutes and 49 seconds, counsel.
Thank you, Your Honor. And let me correct something here. I was not counsel in the lower court. I remembered, but apparently I didn't remember very well that it was argued in the transcript. My memory has now corrected. I don't believe it was argued in the transcript, but it was argued by us on appeal. I am not aware of a case that requires it to be argued below, since it's a motion to dismiss, and there's pretty clear case law on that, but I wanted to correct my response to you. I want to turn quickly to the Cedars of Lebanon case. In that case, Your Honors, the actual use doctrine applied because the actual use on the first was a non-ag use. The property was actually being rented out as a hotel as found by the court. Now, I want to tell you, I have looked at every single case in preparation for this hearing that I can think of and find as it relates to assessments. Not a single one withstood or was dismissed on a motion to dismiss. And Conrad says why. Conrad says these are facts that have to be tried. So we should be allowed to amend if it's needed. But we think we've alleged a short and plain statement that it was being used appropriately on the first. We've alleged that the appropriate statutes, the jurisdiction, all of those things, those are the pleadings. We don't need to plead evidence. We don't need to establish evidence at the motion to dismiss stage. We would ask the court to consider these cases.
Counsel, just so I can be, I just want to be clear, and I appreciate your candor to the panel here, but I just want to make sure I'm understanding. You're saying that you are not sure that there was a request to amend in the trial court. Is that what you're saying now?
I am uncertain of that.
Okay.
I was not the trial court counsel. We did ask for that in our appeal, of course.
Sure, I understand. I mean, I think we have binding cases that say that if you want to argue it on appeal, you have to preserve it below by making give the trial court the opportunity to do that by making the request. But obviously we can go back and look at the hearing and see. So just so your clarification is you're not sure either way.
I am not sure either
Okay.
way, and I contend that the allegations in the complaint are sufficient as they exist because we've alleged that it was used for that purpose on January 1st, enough that we should get by a summary judge or motion to dismiss. Now, there are other procedures, as we all know, summary judgment and otherwise, but those all require evidence, and we weren't allowed to present that. Thank you, judges.
All right. Thank you, counsel, on both sides. Well done. And with that, the court is adjourned.
Thank you.